The American Veterans of Igbo Descent, Avid, has described as perversion of justice the ruling delivered by Justice James Omotosho of the Federal High Court Abuja on the no-case submission made by the leader of the indigenous people of Biafra, Nnamdi Kanu. A statement made available to journalists and signed by Avid President Sylvester Onya says the ruling betrays the administration of Criminal Justice Act, AJA, the Evidence Act, and the Constitution. The statement issued by the legal department of the American Veteran of Igbo Descent, Avid, under the authority of its president, Dr. Sylvester Onya, noted that Justice James Omotosho's ruling on the no-case submission of Mazi Nnamdi Kanu stands as one of the most troubling examples of judicial dereliction in recent memory. The group also says the ruling betrays the people's faith in the judiciary as the last hope of the common man. The statement further says, and I quote, "No evidence linked Kanu to any offense. Nobody testified that Kanu incited them. No bomb, no bullet, no gun, nothing. Only edited broadcasts downloaded from the internet in 2025 for offenses allegedly committed in 2015. The proscription of IPOP touted as justification was itself done in contempt of fair hearing and a substituting order that states that IPOP is not an unlawful society. This is not prosecution, it is a pathetic charade." The constitutional breach. Omotosho also trampled on Section 36 of the 1999 Constitution, which guarantees a fair trial. These protections are non-derogable, which means that Omotosho cannot ignore it or pretend not to know it exists. Any violation of any aspect of Section 36 of the Constitution of Nigeria terminates the trial of Mazi Nnamdi Kanu as a matter of law, and Omotosho knows this. By sustaining this charm, Omotosho made himself complicit in stripping away constitutional guarantees and propping up a trial that should never have survived. A judge who forsook his oath, Justice Omotosho, once invoked God's guidance when taking charge of this case. Yet, in his ruling, he abandoned divine guidance for political expedience. He refused to apply AJA 2025, refused to obey Section 122 of the Evidence Act, and refused to acknowledge the Constitution that gave him the power to be a judge.